I'm John Wirtz, Montgomery County Tea Party, and we are here with Judge Ray Wheless, and he is running for the Criminal Court of Appeals. I wanted to say that correctly, and not Criminal Court of Appeals, place two. Right, and so what we'll do is start off, Judge, with you with a 5-minute opening, and then we'll do the Q&A after that.
Okay. You want me to just tell you a little bit about my background?
Yes, sir.
All right. My name is Judge Ray Wheless. That's not my first name is Judge. My first name is Ray. But people call me Judge, so I usually start out that way. And I've been a district judge now for, let's see, 6 years, 7 years. I was appointed by Rick Perry in 2009. Before that, I was a county court of law judge in Collin County. I was appointed by the executive committee in 2000 and served until 2009, so about 9 years. As a county criminal court judge, I heard mostly criminal cases, but some civil cases also. I was selected by the executive committee. There were 16 lawyers that applied the night that I was selected. There was a vacancy, and so after we did the formal interview, written, and then we did questions and answers and speeches and all that, out of those 16 people, I was selected. So to me, that was a big honor. When Governor Perry appointed me to the district court bench, that was an honor, but it wasn't quite as big as being selected by my peers in Collin County. So I was really proud of that. I've been a judge now, so a total of 15 years. So before that, I was in private practice in Collin County for 20 years. When I was in private practice, I handled all kinds of cases. I handled criminal cases. I didn't do divorces. I hate divorces. But I did criminal cases. I did civil cases, personal injury cases, real estate. I did a little bit of everything. So I have broad experience in all areas of the law, which I think is important because when you look at judges in general, for example, federal judges, all of them have general jurisdiction. All federal judges hear both civil and criminal cases. The United States Supreme Court hears both criminal and civil cases. Texas and Oklahoma are kind of unusual in that we have a system, just Texas and Oklahoma, where we have a Supreme Court case that hears civil cases, and then the Court of Criminal Appeals hears just civil cases. And so I'm running for the Court of Criminal Appeals because I think that we need constitutional conservative on the Court of Criminal Appeals. This court is the last defense for wrongful convictions, for forfeiture of property without due process. There's just a lot of things that this court is really important to address, and it deals all with our rights under the Constitution. So that's why I'm running. I'm not one of the typical Republicans that might run for this court. This court has a history of electing prosecutors, has a history of electing defense lawyers, so it's either usually one or the other. I guess I'm kind of down in the middle because I don't really fall in the category. I was never a prosecutor, so I don't fall in that category. But I don't also fall in the category of criminal defense lawyer because although I did some criminal defense work, most of my work was in the area of civil. I'm board certified in civil trial law, board certified in personal injury trial law, but also tried criminal cases. At one point I had 19 in a row not guilty on criminal cases. That wasn't my main thing. My main thing was to handling personal injury cases, but I also did criminal cases because that keeps you in the courtroom. So my background is really broad in those areas. As a lawyer in private practice, I was AV rated by Martindale-Hubbell, which means I was in the top 5% of all lawyers nationwide for ethics and legal ability. So then in '89, I became board certified in personal injury trial law, in 1990 civil trial law. And I was president of the Collin County Bar Association, president of the Plano Bar Association. Currently, I serve as chairman of the Specialized Courts Advisory Council to Governor Abbott. Let me explain about that. In 2005, I saw the revolving door of people getting arrested for DWI. They'd leave, they'd come back, they'd get arrested, they'd come back again. So I decided in 2005 I wanted to do something about that. So I created a DWI drug court program, put people in there, try to get them clean and sober, but also make sure the community was protected. They had to have a deep lung device, they had to have insurance, they had to do all those things that we required. They had to come to court every week and see me every week for the first 90 days and then every other week for the next 90 days. And then once a month thereafter. So recidivism for people in drug court programs is much lower than regular probation and certainly much lower than people who go to jail. So I started that drug court program in 2005, and then in 2009 when I was appointed by Governor Perry as a felony court judge, I started a felony DWI drug court program. Currently I serve as chairman of the Specialized Courts Advisory Council to Governor Abbott. I was appointed originally under Governor Perry, but when he left and Governor Abbott took over, I continued as chairman. So what we do is we go out and we recommend Best practices for specialized court programs like Veterans Court programs, DWI court programs, mental health court programs, and we recommend to the Governor's Office which one of those programs should be funded. And so that's what we do, that's what the committee that I'm on now and chair does. Also, I'm president-elect of the Texas Association of Drug Court Professionals. What that organization does is provides training for people in the drug court field statewide. Drug courts have much lower recidivism than people who are released from prison. If a person's in prison, let's say you send someone to prison for DWI, usually after a felony DWI, a person gets out, 1/3 of them are going to commit a new crime within 3 years. But someone that graduates from a drug court program, DWI drug court program, only about 16%, so it's less than half. And in some cases, in some drug court programs, it's even lower than that. So drug court programs have been proven effective. Is that time up?
Yeah, you
Go ahead, finish.
Okay.
Yeah.
And as a background, I was involved in the Republican Party. I was a precinct chair, election judge, vice chairman of the Republican Party. And so I have a long history of involvement in the Republican Party. I didn't just show up like some lawyers. Y'all seen these lawyers that show up and they haven't done a dang thing, and all of a sudden they want to run for office, and they haven't done anything. They haven't worked in any Tea Party groups. They haven't worked in Republican groups, but they just want to come and get elected. Well, I worked my way up. Starting in 1980 in Collin County, there were still Democrats countywide. Well, I came in and with the party and helped get rid of them all. So we had our last one countywide in 1984. Hadn't been one since then. I was appointed previously by Governor Bill Clements as a public member of the Board of Chiropractic Examiners. That's on there also. I'm not a chiropractor, I don't know anything about chiropractic, but I was one of those people who supervised the chiropractors to make sure they kept their hands where they were supposed to be. Sometimes they get a little too friendly, and so if somebody, usually female, made a complaint, we would address those issues, and so that's what I did, is help regulate the profession. I've been endorsed by a lot of what people call establishment Republicans. Tom Pauken used to be chair of the Republican Party of Texas, Kathy Adams, president of the Texas Eagle Forum, former chair of the Republican Party, Craig Enoch, former Texas Supreme Court Justice, Sue Holland, former judge on the Texas Court of Criminal Appeals, who's also from Collin County, Jim Mosley, former justice on the 5th District Court of Appeals. But then I got a lot of people that I don't think you would call traditional Republicans, certainly all the Tea Party people that have supported me and endorsed me. People like Julie McCarty from Northeast Tarrant Tea Party, Joanne Fleming from Grassroots America, We the People, Tyler, Ray Myers from Kaufman Tea Party, the leaders of the Allen Tea Party, McKinney Tea Party, leaders of the Fort Worth 912 Project, so that's not on there, but a lot of those people have endorsed me. Ronnie Stapleton, Adrian Murray, Georgia Stapleton. So in my county, everyone in my county just about that I can think of has endorsed me. All the county commissioners, the county judge, the sheriff, the district attorney, all the constables, and that extends out to the counties around me. For example, in the county to the north of me, Grayson County, the DA up there has endorsed me. The former chair of the party up there has endorsed me. In Denton County, the DA's endorsed me. The sheriff has endorsed me. Rockwall County, we've got lots of endorsements over there. Kaufman County, Hunt County, tons of endorsements from the area all around there. Bob Drieger, former chairman of the Dallas County Republican Party, has endorsed me. Clyde Seidman, former chairman of the Grayson County Republican Party. Bill Baker, former chairman of Kaufman County. And let's see also, we've got some pretty important endorsements by lawyers. A lot of times you can judge about the character of a person and their abilities by who endorses them. I believe that, so I think endorsements are important. Not only am I endorsed by prosecutors who know me well, but also people, the #1 lawyer that won the Lawyer of the Year award last year by the Texas Criminal Defense Association. Her name is Heather Barberi. She's endorsed me. The lawyer who is the immediate past president of the Texas Young Lawyers Association, Christy Blanchard, she's endorsed me. Some of the SREC members have endorsed me from my area and other areas.
Okay. All right, great. Well, thanks for that overview. I was just pulled up your completion of our questionnaire.
Okay.
The first question was the job of this, well, I had state Supreme Court, but it was Court of Criminal Appeals. Sorry, I didn't get that changed. And what is your judicial philosophy? And you indicated you believe in judicial engagement. Can you explain what that is?
Sure.
Please.
Judicial engagement is the opposite of judicial activism. Judicial activism is where judges do something that they have an agenda, something that they want to do, a policy decision that they make, which is in violation of the Constitution. Judicial engagement is where a judge or judges working together, if it's an appellate court, would decide that something is in violation of the Constitution and wouldn't let precedent stand in the way if it truly violated the Constitution. And so that's judicial engagement is the philosophy that I believe in. I believe that when there are instances, situations, including case precedent that's in violation of the Constitution, judicial engagement is something that the courts ought to look at as a way of fixing that problem.
When have you always had that philosophy, and where do judges basically make that turn to get away from that? What happens there when they do that?
I'm not like a lot of judges. I'm a little bit different. Like Ted Cruz is different from most senators. And so in my county, they refer to me as the honey badger judge. Have you ever seen the video of the honey badger? It's a little animal that lives in the desert in the Kalahari. And
I went to LSU, so
you know about it.
I know
okay.
about it.
Well, there's this little animal, and it's not afraid of anything. It's not afraid of cobras. It'll kill a cobra and eat it. It's not afraid of lions. Nothing. It'll attack anything, although it's real little. And so the lawyers in my county call me Judge Honey Badger because I'm not afraid to stand up to authority figures like the district attorney. We had a runaway DA that I stood up to. And so I've always had that philosophy of doing things differently. I don't have time limits on jury selection. I let people have their day in court. I don't have time limits on opening statements, closing statements, nothing. I let the lawyers come in and try their cases. People are entitled to their time in court. And some of the other judges are a little bit resentful for that because it makes them look bad, they think. And I say, well, if you don't like it, change your philosophy. Give everybody unlimited time. I dispose of as many cases as you do.
Mm-hmm.
So...
Okay, all right, great. Okay.
So I guess following along that a little bit, not a criminal case, but just get an idea of how you would rule on certain issues. Back in 2000, there was a contested presidential election, and the Supreme Court in Florida got very involved in that issue, and that went up to the U.S. Supreme Court. They each engaged themselves. So I guess I presume you're familiar with those details reasonably well. What are your thoughts on each of the rulings from the state court and from the Supreme Court?
I don't think the United States Supreme Court had any business getting involved in that. It seems to me that that was a state issue. It's the Florida Supreme Court was the one that should be deciding that issue. The people of Florida should be deciding who won the election in that state, not the United States Supreme Court. The United States Supreme Court declared a victor in that case, and I don't think that they had the authority to do that. We believe in the 10th Amendment as Tea Party people, and believe that states should have made that decision. I think most of the judges on that panel, too, regret that decision.
And what about the state Supreme Court? Did they make the right decision?
Well, as I understand, they ordered a recount, as I recall, and so I think that ordering a recount is something that the Supreme Court probably should do if there's a situation where the ballot integrity is in question. We had a case in Collin County where there was a recount ordered, and it went back and forth because every single time they would count the ballots, it was for county clerk, it would come out different. So they'd count it, and this clerk won by 1 or 2 votes, and then they'd recount it, and then that clerk won by 1 or 2 votes. And you never really could tell who won the election, so one of our local judges ordered a brand new election. So yes, I think that in the appropriate case, on a local level, courts should get involved in things like that if there's questions about ballot integrity.
Including redefining the statute to set a different date for the end of the count?
I don't know if I would go that far. I think that everything has to be done according to the standards for the federal election. So
okay. They
needed to comply with whatever standards and rules were in effect at that time.
Okay.
Okay, I trust that you're familiar with the press release that Governor Abbott put out, was it end of October, having to do with the Dallas County Sheriff and their implementation, if you will, local decision to implement what we would call sanctuary city policies. Governor Abbott came out with a couple of statements there, basically said we're not going to tolerate this in Texas, and that's a nice philosophy, but what authority does he have in that regard?
Well, he's the chief executive officer for the state of Texas. So it seems to me that he would have some authority in that area, because I know the federal government is primarily responsible for border security, but the governor, and we have a Texas State Guard, has some obligation to defend the border. And so I know that the feds want to come in and take over all things immigration, but those are issues that affect us. So I think the governor does have a right to come in and tell cities that they can't be sanctuary cities. I think he has that right as the chief executive officer for the state.
So then he could unilaterally implement that. We wouldn't have to worry about the legislature passing sanctuary city legislation.
Well, I think always we want the legislature to act, because we elect the legislature. We also elect the governor, but I think our preference always as conservatives is to have the legislature take action on issues like that. So the governor may take some action like that, but I think that it ought to be backed up with legislation passed by our Senate and our House.
Okay. Okay, thank you.
Why this race and this position, this place?
I've always wanted to do primarily criminal. I tried to get the other judges in Collin County to agree to let me just do criminal only, and they wouldn't agree to it. And so I said, well, we can arrange this so that everybody can divide the workload up, and so people can do what they want to do, specialize. And they were against it, and I was in favor of specializing. And so I wanted to do criminal only, so I started taking a look at the Court of Criminal Appeals, because it's a place that I can go and just do criminal only. And I'm interested in making sure that the erosion of our rights under the Fourth Amendment and other rights that we have in Texas are addressed by the Court of Criminal Appeals. And so right now, there's a situation with the Court of Criminal Appeals where we had a judge there who switched to the Democratic Party. Larry Myers was a Republican. He got elected, I believe, in '92. And he was a Republican until 2013, when he switched to the Democratic Party. And he ran for the Supreme Court of Texas against Jeff Brown. He lost, but he's still there. No one really knew what he was going to do. We didn't know if he was going to try to hang on as a Republican and run again, or file as a Democrat. Well, on December 14th, he filed as a Democrat in this race. So he's the only statewide Democrat office holder. And his opinions, a lot of times he doesn't even participate in the decision. He will just say that he dissents without writing an opinion. So it looks to me like, well, he's just occupying space if he's going to do that. If you're going to dissent, state the reasons why you dissent so that people will know, and that's important in our judicial process. So we have someone there that needs to be removed. I started running for this office a year ago. The other two people that are in this Republican primary with me, they just recently came to the party. They're late to the dance, as the saying goes.
Is that... all right, so Myers is the incumbent, and you came in quite a while back, so Mary Lou Kill and Chris Oldner are new
They are.
to the dance.
Chris Oldner particularly new within the last few weeks.
Oh, really? Okay. All right, thanks, Ken.
All right. So you've indicated that you're willing to kind of go outside normal bounds. The NSA is spying all sorts of stuff against our electronic data and our phone records. What's your position on that, and what happens if a case comes to you that relies upon some of that data?
Well, I think in general, a lot of the stuff that came out of 9/11, Patriot Act and all that, needs to be changed. I mean, a lot of the stuff that was passed was done because we were fearful, we were terrified, we wanted to do what we could to stop future terrorism acts. But what we saw was a lot of overreaching by the government. So a lot of that needs to be pulled back. I'm not sure that I would have that in front of me, but if I did, if it was stuff that was obtained illegally under federal law or state law, I wouldn't allow it to be used. We have a special statute in Texas called Article 3823 that says that any evidence that's in violation of the Fourth Amendment can't be used, and so you just throw that out. So we have our own suppression statute in Texas, and I believe in that. I'm a big proponent of the Fourth Amendment. My opponent, Mary Lou Kill, is making a big fact out of that I have several reversals on cases that went up to the Courts of Appeals. Those are all cases, most all of them, dealing with the Fourth Amendment, because I have a different view of the Fourth Amendment than people on the Courts of Appeals. Courts of Appeals attract a lot of establishment-type Republicans, a lot of former prosecutors where the government is always right and the state always wins. And so what I have done is that on Fourth Amendment issues, I let the parties come in pre-trial and have a hearing on the motion to suppress. And then I tell the state, if you don't like my ruling, then you can appeal it. So then they appeal it. And so those go up on appeal, those get reversed. So Judge Kill, when she comes to interviews with you, she's going to talk about that. And then what happens when those cases come back is that then those cases go to trial, and a lot of times they're, you know, not guilty. Or a lot of times there'll be a plea bargain where that was all a waste of effort. So it really is a waste of taxpayers' money for all that appellate process to take place when it really didn't need to. And so I'm very strong on the Fourth Amendment. And I've told the appellate judges in Dallas that. We had a meeting one time where all the lawyers were there in the local bar, and I was on the panel, and there were appellate judges in the audience, and this issue came up, and I said, I have a different view of the Fourth Amendment than those Dallas judges do, and I think that's well known in my community.
Okay, you made at least a couple of references that I found so far to the word reform, and I'm trying to understand where you're coming from on this. Certainly reforms can be needed, lots of reforms are needed, but the reforms come from the legislature and not from the bench. So can you elaborate a little bit, clarify that for me as to what you are talking about when you're talking about running for the Court of Criminal Appeals? How do you see that implementing reform? Is in the way decisions are disposed of?
There's a lot of case law. We like to think that the legislature makes all the law, but we know that judges make law too. And so what happens at the appellate levels, the highest courts, the Court of Criminal Appeals, the Texas Supreme Court, decisions are made that affect people's rights all the way down, dealing with search and seizure, Fourth Amendment, everything else. I'll give you a good example. One of the exceptions that's been crafted by the Court of Criminal Appeals is to the requirement that you have reasonable suspicion to stop someone or a warrant is a community caretaking exception. So if a police officer sees someone on the side of the road and the police officer says, well, I just wanted to stop, check on him, see if he was okay. Well, that's something that was created by the court. It wasn't created by the legislature. And so if a police officer stops you on the side of the road to check and see if you're okay when you're out there minding your own business, that's something that I'm not sure that we want to keep allowing gradual erosions of the Fourth Amendment. So that's something I think that needs to be taken a look at. I'm just one judge. Depends on what the rest of the panel thinks about that issue. To me, there has been a gradual erosion of the Fourth Amendment that the Court of Criminal Appeals is capable of addressing. Judge-made law. I'm not talking about anything that the legislature did. Although I will tell you, my last case to the Court of Criminal Appeals before I became a judge involved the Fourth Amendment. I had a fellow that I was representing. He was out on a boat, minding his own business, out on the lake, and the game warden came along and stopped him and said, let me see your ID. Let me see your boat. Let me see your life jacket. Let me see your life preserver. Make a long story short, he got arrested for DWI. And so the issue was whether or not he had the right to stop him. And so there's a statute in Texas that says that if you're on the water, it's called the Water Safety Act, a game warden can stop you just to check all that equipment, fire extinguisher, all that kind of stuff. I argued that that was unconstitutional. The Court of Criminal Appeals didn't agree. That was in 2000. And they ruled against us, and my guy pled guilty. A lot of people plead guilty even when they're not guilty because they can't afford a lawyer, they can't afford to go to trial, things like that. So he did plead guilty to that charge of driving while intoxicated, but he shouldn't have been stopped in the first place. There's a lot of times people are stopped for pretext. Whenever you're out on a boat, game warden wants to stop you. It's a pretext. They stop you to check what they call as your life jacket. They really want to see if you're intoxicated, which is okay because we don't want to intoxicate people out on the lakes. We don't want to intoxicate people on the road either. But we don't allow on the highway for a police officer just to stop you to see if you got a driver's license. That's not allowed. Why should they be allowed to stop someone on a boat just to see if they got a life jacket?
Good point. Is the entity that you're seeking to be elected to effectively fulfilling its role right now?
I think that it is. There's been a lot of criticism about this court over the last, I don't know, 20 years. That it was so prosecution oriented that an average person couldn't get a fair shake. That everything was going to be rubber stamped when it went up there. They approved cases where the lawyer was asleep during the trial. Y'all probably heard about that. So your lawyer's asleep, and they say, "Oh no, that's okay. That's you know." There was another lawyer sitting over there. The primary lawyer was asleep, but this guy was over here. So the Court of Criminal Appeals said that was okay. So yeah, there were some issues like that. There were issues. One of the judges, they were trying to file a motion to stay in execution. One of the judges said, "No, we close at 5," and the guy got there just a few minutes after 5, and so couldn't get the stay filed. The guy was executed. And so there needs to be some things like that that are put in place to address those kinds of issues. There were some people that were elected last time. I don't know if y'all were endorsing or were involved in some of those races, but some of the people that were elected last time have brought some needed changes and fresh blood to the court. And so I think that where we are now is that that court is in the process of turning around. But it needs still people that are going to be concerned about the Constitution and people's rights more so than the government always being right.
Okay. Got a little time left. What are the three main reasons you believe you are more qualified than the others in the race right now?
Three main reasons. Well, I have broad experience. One of my opponents went straight from law school to the district attorney's office, has never represented a human being, only represented the government, the state. Doesn't know what it's like to represent someone who might be innocent of a crime. I've had that issue before where I went home after someone was found guilty and thought, well, you know, I'm convinced that they were innocent. What else can I do? What else could I have done? And so, yeah, that's caused me a lot of pain. And so I think I have that I can empathize with when cases come up in front of the Court of Criminal Appeals. Court of Criminal Appeals deals with serious felony cases, death penalty cases, but also writs of habeas corpus. So a lot of people that are charged with crimes that are convicted, wrongfully so, their case ends up at the Court of Criminal Appeals. That's one of the most important functions of that court. And the way I look at that is that those cases need to be filtered very carefully through the lens of someone who's independent.
Okay. So we covered one broad experience, so
Okay.
we'll come back.
Okay.
Okay. I lost my, so January 1, we get the new law with open carry. What's your thoughts on constitutional carry?
The government doesn't give us the right to carry guns. We have that right. I think we all recognize as patriots that we have the God-given right to carry a gun if we want to. So I believe in constitutional carry. I was a judge during a time when it was illegal to carry a gun in your car. And so, you know, I had these cases all the time where people would be stopped. There would be some pretext reason for the stop. You can usually find a gun in a car. And a lot of times I had a lot of cases where people were charged with unlawfully carrying a weapon. Anytime that there was a defense promoted or put forth that the person was traveling, which was a defense to unlawfully carrying a weapon, that was something that was very viable in my eyes. Some of those issues with those motions to suppress, it also deals with those issues about the guns also, about the reversals. Because I believe in the Second Amendment and I believe in constitutional carry. The government doesn't get to tell us we have a right to carry a gun. We have rights, not the government.
Okay, this one may be an easy one because you may be able to say it. I agree with you that there is, from the articles I read, there's much abuse on civil asset forfeiture. I have no problem with civil asset forfeiture once there's a conviction established, but prior to conviction, that shouldn't happen. So, again, from the standpoint of the Court of Criminal Appeals, what can you do about changing that? Again, is it establishing case law? Does something like that ever reach the level of Court of Criminal Appeals? What is your position on how to effect change there?
Well, this civil forfeiture business is something the legislature created. So unless the Court of Criminal Appeals is willing to wade into that arena and say that that is unconstitutional, I think we have that statute in effect. I had a case where I had a young man that was dealing drugs, and he was in his mother's car, and he didn't know. I mean, she didn't know. She didn't know. Her car was seized from her and sold. So yes, it's an issue. It's an area of the law that needs to be addressed. And I'm not sure that just because someone is convicted that other innocent owners should pay the price for that. So I think those are things that certainly the court should take a look at if the legislature is not willing to address it.
Okay. John?
Okay. When is a judge justified in striking down a legislative act?
Well, I kind of explained that earlier, the judicial engagement. Whenever it is contrary to a constitutional provision, either the U.S. Constitution or the Texas Constitution. I mean, I think we all elect our legislators to pass laws. We don't want judges to pass laws. But if a judge sees that the legislature has overstepped its bounds and done something that's against the Constitution, then I think that's appropriate to strike it down.
So, some pretty big pieces of legislation were passed by the Supreme Court dealing with Obamacare, the Marriage Act. Can you elaborate? I mean, this is something that may eventually come down through Texas, just like it did in Kentucky with those ladies at the clerk of court, Miss Davis. Do you expect anything like that to happen in Texas, and how is that addressed, maybe from your perspective, based on your experience?
I don't think those issues would be before the Court of Criminal Appeals because those issues would end up in the Supreme Court of Texas, and so I don't think I would deal with those. I don't think that the Supreme Court had any business getting involved in defining marriage. It's not a federal issue, it's a state's issue, if it's even a state issue. I mean, really it's between a man and a woman and their God and their minister. But if we're going to have state-sanctioned marriages, well then it's up to the state, not the federal government.
What's your opinion on that? Should states sanction marriage, or should it just be a contract between man and woman?
We have a history of sanctioning marriages, so I'm not against it. So I think that it's a good thing because not everyone goes to a minister to get married. A lot of people just go to the Justice of the Peace.
Right.
And so if you just go to the Justice of the Peace, it's kind of state sanctioned already.
Okay. I mean, I know that's out of your purview.
Right. Sure, it helps you tell the
foundation.
Yeah.
All right. In the recent presidential campaign, a suggestion has been, or concerns have been raised over immigrants from Syria, and potentially even all immigrants that claim to be Muslim. So what's your position on that?
My position is I don't know how many more foreigners we need living in this country, to be honest with you. I mean, I'm talking about people that are mostly illegal immigrants coming to this country. But even people who want to come here, even if they receive visas and they're wanting to come here to study or things like that, all the foreign students that come, I don't know how many more people we need in the United States from other countries. I'm not saying I'm anti-immigrant. It's just a question that really needs to be addressed, is that why do we keep bringing so many, or letting so many more people come to this country when we have people here that can't find a job, we have people here that can't get into the right schools. So why do we want to keep bringing people from other countries? Are we the world's caretaker? So that's my view.
But is it appropriate for us to make those decisions based on their religion or from the country of origin versus other characteristics?
I don't know based on religion, because then we might fall into a pattern of discriminating all religions, and so I don't, but you know, we're talking about U.S. citizens. With the Constitution bans discrimination or based on religion for people here in the United States. If people come here that aren't from the United States, and last time I checked, all the terrorists were Muslims, I think that's appropriate. I don't have a problem with it.
All right.
Okay, this ties in a little bit. Answer question number 14, what extent do you believe the state or federal government should be able to obtain court orders and directing parents to do things for their children? And you answered only to save the life of a child. For example, a blood transfusion a parent will not agree to. There are some religious doctrines, religious sects that do object to blood transfusions. And so in that case, you think that the rights of the state or the decision of the state should trump the decision of the parent, I would assume.
I do, because if you're pro-life and you want to save human life, if you've got a child that a doctor says is not going to survive, without a blood transfusion, the life of that child is more important than the religious beliefs of the parent.
Okay, so religious freedom is secondary then?
Not secondary, but life is very important, and so preserve life first. That would be my answer. Yes, I'm comfortable with that. Protect life first, and those parents are just going to have to understand that we saved their child's life.
Okay, John?
Okay, how do we tell if the treatment the doctors are suggesting is actually better than what the parents are suggesting?
Well, I'm talking about a case where a kid is in a car wreck and he's in the hospital and he's lost 40% of his blood, and the doctor says if you don't give this kid a blood transfusion, he's going to die. And I've signed that order before.
What if the parents have another set of doctors that disagree with that set of doctors?
I haven't ever seen that, but if they did, I guess that's a situation we'd have to address at that time. But I have signed orders before requiring a transfusion whenever there was a kid about to die, and the doctor said that.
Okay. Your next question.
I assume you're familiar with the candidates, is it an act, a Judicial Ethics Act? What's your opinion about that, the restrictions that they place on judges campaigning?
I think they're unconstitutional.
Okay.
I believe in the First Amendment. I believe in the Citizens United decision. I believe the judges should be able to say what they want to say during an election. If a judge wants to say he or she is pro-life, they should be able to say it. If they want to say he or she is whatever the situation is, they ought to be able to say it. The Supreme Court said that judges are not politicians. They said that judges are not politicians, but we run for office in Texas and we act like politicians. We run around, we raise money, we get out and we go door to door, not statewide, but locally. And so really in Texas, we kind of are politicians. So not to have your hands tied where you can't talk about things seems to me like it's a violation of the First Amendment.
Okay, we're about 30 minutes into it, so roughly 15
Okay.
minutes.
I'm sitting here trying to struggle, and I haven't thought this through thoroughly, so please help guide me. There's been a lot of discussion of the decisions that come down from the Court of Criminal Appeals and their effect on the community and so forth, and you stated, and not an accurate statement, but along the lines of judges do rule from the bench. And yet, you're also, in your answers, you come across and state very clearly you are a strict constitutionalist. The Constitution takes priority, takes precedence, and so forth. And so I'm struggling with this apparent dichotomy between case law and Constitution, case law and Constitution. Can you help clarify that for me, please?
All right, I'll give it a shot. The Texas Supreme Court and the Court of Criminal Appeals and appellate courts in Texas do make law because they, the way they rule and handle cases, they decide case precedent based on situations in front of them. I'm not saying that I believe in that, but that's an ongoing process now. That's what judges do on those high courts. The Supreme Court has done that. The Supreme Court has created causes of action in civil cases that didn't exist. The legislature didn't create it. The Texas Supreme Court did. The Court of Criminal Appeals has created exceptions to the Fourth Amendment that the legislature didn't create. The Court of Criminal Appeals created it. Those courts created it. I'm not saying I would. I'm saying that I'm a constitutional conservative. And so, for example, if I'm on that court, if something is in violation of the Constitution, I'm not going to vote with the other judges to create a new cause of action or some exception that that's not constitutional.
Okay.
Is it deliberated between y'all before a decision is made, or is it just, here's what it is, and you have 4 for and maybe 1 against?
The judges sit down and they read all the briefs, they read all the record, they know what the statement of facts is from the lower court, and then they sit around a table like this and they conference and they talk about it, and they talk about, well, this exception applies to the Fourth Amendment. This search was valid for this reason. Another judge will say, well, no, I don't agree with that because in this case, this is what the facts were in this case, and this is what the holding was in that case, and here's what the Constitution said. So judges do get together, and sometimes you'll see 5 to 4 decisions out of the Court of Criminal Appeals or the Supreme Court. Sometimes the dissenting opinion later might become the majority opinion in a different case. So it's important to have those discussions sitting around the table to try to flesh out, okay, what am I missing here? Why do you see it that way? Tell me what I'm missing. And so, you know, judges sometimes change their opinions on those cases. And sometimes judges have changed their opinions on motions for rehearing. They may render an opinion, and then one party or another will say, I would like to have a rehearing, file a motion, and address the reasons why the court reached the wrong result. Then the court will go back, reconsider the case, and maybe come out with a different opinion.
Okay.
You want to take my time? Did you?
I was going to say, you took the last half of mine, I'll take the first half of yours.
That's fair enough.
Okay. Okay, now to rephrase what I had in mind. What I see here is, again, I'll still call it a dichotomy to a degree, because you frequently cited the Fourth Amendment. The 10th Amendment is based on nullification. I'll assume that you are, presume that you are fully in support of the 10th Amendment as well. And yet nullification, kind of to me, as a non-lawyer, the heart of nullification is you made the wrong decision and I'm not going to abide by it, whether it's jury nullification or whatever the case might be. So from the standpoint of nullification, if you disagree with how a court rules, the ultimate is go back to the Constitution. So you seem to be saying that a lot of the courts are not going back to the source to find the real basis for a decision. And am I misinterpreting you in that?
No. The easiest thing for a judge to do, for a lazy judge to do, is to just follow precedent. So a lot of times the Court of Criminal Appeals, the Texas Supreme Court, and various courts of appeals will just look at precedent. So, all right, here's the fact pattern, here's what happened here, and then they'll just look at their prior case decisions and say, well, here's what we decided last time this issue was before us. In other words, they don't go back to the Constitution and reevaluate it. They take a shorthand route and still say, here's what we decided last time. And you know, some people like that because that ensures predictability in the law. A lawyer can tell you that if you've been arrested based on certain facts, the Court of Criminal Appeals has previously held, or the Texas Supreme Court, different case, civil case, has decided a case a certain way. There's predictability that way. They can tell you this is probably what's going to happen. If the Court of Criminal Appeals and the Court of Supreme Court went back to the Constitution every time in every case, lawyers would be guessing about what was going to happen. So that's one reason why people follow and want precedent to be followed. But precedent should not be followed if it's against the Constitution. So those judges who go back to precedent in a given situation, they shouldn't stop there. They should look at the precedent and say, okay, here's what we decided last time. This case controls, but was this case decided properly or not? And so let's look at the Constitution. And if it wasn't decided properly, then let's get rid of that case.
Okay, that's more like what I heard here. Okay, John.
Yeah, it's kind of along the same lines of you either hear a story from the source or it goes, you know, first, second, third source. So, right?
Right.
And that's what's happened to the country, basically. We've gotten so far away from the Constitution because of precedents and maybe a derivative of the first precedent, instead of going back to the anchor.
Absolutely.
Okay, so back to my question, what are the three main reasons you believe you're not just qualified, but most qualified for this office? The first one you said, just refresh, is broad experience. What about 2 and 3?
Okay, I'm a conservative. I'm a constitutional conservative. I'm not sure that one of my opponents, Judge Kill, is even a conservative. She's married to a Democrat personal injury trial lawyer in Houston. He ran for judge in 2014 while against a Republican incumbent friend of hers. She ran for re-election as a Republican. He ran as a Democrat. During the course of that, he trashed conservatives, said that they were responsible for a lot of problems in the civil justice system. If he got elected, he was going to rectify that, level the playing field. Some other things. She's endorsed by a police labor union in Houston. It's AFL-CIO labor union. Her brother Terry Kill ran for the Court of Criminal Appeals in 2005. Joe Strauss endorsed him. She's endorsed by Kent Hance, congressman, former congressman from West Texas. He's on Joe Strauss's campaign finance committee. I don't have any ties or connections like that with any moderates or, I guess, if you want to call them liberal Republican groups or liberal candidates.
We call them establishment.
establishment. So
Redis County.
I'm not sure that she's a conservative. I mean, I know she's been doing this for a long time. She's a qualified judge. She's been sitting down there hearing cases. I don't know if she's a conservative. I am a conservative. I've been doing this for a long time. The people who know me say I'm a conservative. So that's number 2. Now number 3. I'm working hard. I'm working harder than anybody in this campaign, and I've always worked harder than anybody. Did I tell you yet about my background, my personal background? Did I tell you that yet?
No more of your professional background, not as much
Okay.
personal.
Well, my mom and dad were poor, blue-collar people. My dad dropped out of school in the 3rd grade. My mom dropped out of school in the 8th grade. No one in my family had ever gotten a high school diploma. And so whenever I dropped out in 10th grade, you know, I'd gone farther than they had, so that was pretty good. Because I went to work in the oil fields, but after doing that for a year, I was hot in the summer and cold in the winter and dirty all the time and wet. So I said, man, I messed up. I need to do something different. So I joined the Air Force and took the GED test, started going to college at night. And so during my 4 years in the Air Force, I completed 3 years of college. Got out of college, came back to Texas, went to UT Law School. I've always worked hard. And so I'm able to accomplish a lot. I'm a hard worker, and at work I work hard. I get, you know, all my stuff done. My desk is clean constantly. I don't allow anything to sit on my desk. I don't believe in delay. Whenever someone comes in my court, I rule immediately. There's none of this, hear the case, decide months later. I'm working harder than anybody else. There's a guy named Bob Mabry who lives here in Conroe. Do you know Bob?
Makes sense.
Bob writes an article called Courts and Writing Blog. It's about the Court of Criminal Appeals and the Supreme Court and other courts. And he said in his blog, he said, man, this guy's working harder than any candidate I've ever seen on the Court of Criminal Appeals. I got up this morning, you know, 7, drove down here for my meeting down there in Houston and came up here, and I have been all over Texas. And so whenever I go places, people say, man, you're working hard. And so I'm a hard worker. So if my opponents want to make the same claim, that's great. But I'm going to outwork them in this campaign. Neither one of them are going to outwork me in this campaign. And that's the way I'm going to do the job if I'm elected.
Okay.
All right.
So we got, we're just one more from each, and
Okay.
we'll wrap it up.
So when you overthrow a ruling case law, how far do you go? I mean, a lot of times laws are kind of, you know, just one portion is the offending clause, and if you just remove that one piece of text, it kind of creates a gap in the law. So do you give them guidance on how to reinterpret that law, or what do you do?
You're talking about a statute?
Yes.
Most statutes, when they're passed by the legislature, I worked in the legislature when I was in law school, and so I'm familiar with it. I was a legislative aide to a state rep. Most of them have a language in the statute that says that if any part of this is determined to be unconstitutional, then the remaining parts shall not be affected. So you're right about that. If there's one section, and the court should be as very involved in that as they possibly can. If there's one small section, even if it's one sentence, even if it's one section, one paragraph that should be stricken down, then the rest of it should remain intact.
But do you give any guidance about how to resolve the issue that's around that?
That's up to the legislature to decide. If the court decides that a particular paragraph in the statute is unconstitutional, the legislature can figure out how to work around that. And they do it all the time. The Court of Criminal Appeals has ruled some statutes unconstitutional, criminal statutes, and then it goes back to the legislature and they fix it. I had a case involving the ability of a police officer to stop outside of his county of jurisdiction. And I granted a motion to suppress and threw the case out because a police officer at the time could not arrest someone outside of his city of jurisdiction. And the Court of Criminal Appeals upheld me on it. So then the legislature said, well, let's fix that. And so they passed a statute and they said, okay, a police officer now, and this is the law right now today, a police officer can stop anyone in a city within his county and arrest them. So a Conroe police officer could stop someone in Cleveland, is that in Montgomery County? The Conroe officer could arrest someone in Cleveland. Before they couldn't, but now they can.
All right. Okay.
Last question.
John, I'll defer to you.
I'm done. Well, okay, so please rank the 3 biggest challenges facing you when if you win in this race.
3 biggest challenges facing me.
Yes, sir.
You mean like how I would do the job,
Or maybe facing the entity when you get in there,
The entity?
what you guys are dealing with.
There's always, there's always that talk about this is the way we've always done it, and so it's a natural resistance to change. Also, it's re-education. A lot of people don't want to consider new ideas. For example, my involvement in drug courts, I've been constantly having to swim upstream, fighting people about educating them that the right way to handle things are these new ideas about specialized courts, veterans courts, mental health courts, things like that. And they save taxpayer dollars, they reunite families, they reduce recidivism, and so that's a big challenge. That's one of them, is educating people on the court. Other changes, trying to work with a limited budget. The courts don't get a huge amount of money, so you have limited resources. Some of those resources need to be redirected. The Court of Criminal Appeals has funds that it monitors. The legislature gives money to the Court of Criminal Appeals and says, here, take this money and educate judges and lawyers in Texas. And so they do. They administer this grant money. And so one of the things I'd like to do is to try to get the other judges, and there are 9 there, I need 5, to say, okay, let's take some of that money that we were using for some of these other things, and let's try to educate judges and prosecutors in Texas about ways to better help the public, how to save tax dollars, how to reduce recidivism. Let's do this education in these areas. So that's another challenge.
And let's see, so you have.
And then one more.
Education, yeah, and work with a limited budget.
One more is finding out what system they have in place right now to handle the volume of caseload and see what we can do to decrease the time that it takes. Everybody always complains about appellate cases. How long it takes. Why does it take so long? And so that would be one of the challenges, to go in and take a look and see what the rules internally are for handling those cases, time disposition standards and things like that, and trying to get some agreement about what can we do to change this to speed up the handling of these cases.
Okay, great. So that'll wrap it up. If you want to take up to 5 minutes now to close, and then we'll finish it up and turn off the camera.
Okay. Well, I'd just like to thank the Montgomery Tea Party for having me here today. All the viewers, everyone who's watching, I appreciate the time and opportunity to come here. Wish y'all a very Merry Christmas.
All right.
And I don't have much else to add. I really want to serve on the Court of Criminal Appeals. I believe in serving people and making change in a positive way, and that's what I'm going to do. I'm going to run a positive campaign and talk about the issues. And the issues are my record and my opponent's record, and so I'm going to run a fair campaign. And I hope that the folks out there will consider voting for me, and my website is judgeraywheless.com.
All right.